Imagine for a moment that you are a lawyer in a small or medium-sized American city, and you're good enough to have just been appointed to the bench. Now you're a judge with a whole new set of things to learn. You wake up one morning, as John Burdett Pratt did, and from here on, you'll be looking down from the bench on the very people you were one of the day before. I, John Burdett Pratt,
do solemnly swear.
do solemnly swear. Now what do you do?
I will support.
You're not even sure of the terminology, let alone the rules. The closest you've ever been to the bench is looking up at it from the courtroom. Well, if you're Judge Pratt of Vail, Oregon, you pack up and go to Reno. Yes, Reno. That's where you can go to school and get a crash course in how to be a judge. Less than a mile from the bright lights in the casinos sits the National Judicial College. Nearly 30 years ago, a group of judges and lawyers headed by Supreme Court Justice Tom Clark decided there ought to be a better way to train judges. They created the college.
Remember, it's you against the lawyers now. You used to make money confusing judges and juries. As a lawyer, you just threw up on the wall and see if it'd stick. And if it did, okay. And if it didn't, you tried something else. But as a judge, you're the wall.
Nearly 50,000 federal and state judges have come to the college for part of their judicial education. In most cases, their home states pay the tuition, but some judges pay their own way. And who is the faculty? They're state and federal judges who donate their time. Of all the judges here on campus, Burdett Pratt is the most freshly minted. And one of the things he'll find out is that he'll have to contend with a whole new set of legal issues that have come up since he left law school.
Think about the surrogacy cases. Should we contract for the birth of children? Should you enforce that contract? Should you throw it out? AIDS, the right to die.
What about a child in a child abuse case? Qualified to be a witness or not?
These are the kinds of things that didn't face you as a lawyer. You may have tried to plead it, but you didn't have to finally decide. You wanted to win, but you didn't have to finally decide. And there's a lot of difference when you get to those two positions.
Suppose the question is asked a witness, and the lawyer who called the witness says, I object. Now, what do?
Well, if there's not a reason stated, I assume I'd overrule the objection.
You notice how he hesitated on his decision here for a while? You don't hesitate, do you? They'll think you're reaching for the coin. Yeah, here it is. Overruled. That's it, you see.
Making the punishment fit the crime is what they are trying to do here. But like courtrooms everywhere, different judges hand out different sentences for the very same crimes.
This is the bribe-taking case with a faithless county official, governmental corruption. And which group wants to take a... Judge Schenken, do you want to take a turn at that for your group?
Basically, 2 years in jail was what we felt was appropriate.
Let me see that group in the bleachers up there, in the two-bit seats there.
I think we averaged 6 years to serve and gave him the last year on probation. That was the max.
Then there's the question of language in the courtroom. Not bad language, but words no one can understand. Legalese.
Judge Parton, have you used lexometrics and telebonics in your trial of cases? You never heard of lexometrics and telebonics?
No, sir.
Well, I never have either. They're two just crazy words. Why am I talking about that in a class about jury?
Because, he says, jurors hear words as meaningless as lexometrics and telebonics.
Deposition, interrogatory, voir dire. You know, I've just thrown out a bunch of words that they don't know any more than you know lexometrics and telebonics.
And what do you do to get a kid's attention? Professor Zimmerman tells what one judge did.
And the kid, he said, was standing like this the whole time. And he said, I realized I wouldn't get through to this kid, how serious this was. He said, I decided to take a short recess. I said, and as we take this recess, counsel, would you send your client up to my bench alone, please? He said, I motioned him right over the front of the bench to me. I got about 6 inches, we're all adults here, so I'll tell you exactly what he said. About 6 inches nose to nose with this kid. And in a voice that nobody else could hear, I said, Listen, you little son of a bitch. You may think I'm a nice guy, but if you are in this courtroom again in the next 6 months, your ass is going to be in jail. Do you read me, pal? He said the kid jerked to attention, nodded, and walked backward all the way to the counsel table.
In the substantive area, is there anything that worries you particularly?
One thing I do want to do and will be doing is trying to become an expert on the rules of evidence and try to have that information at my fingertips.
Learning the rules of evidence can be pretty easy, according to Judge Adams.
This is probably the only evidence book you'll ever need. What you do is take it home and take it to your library. Now that's where the porcelain fixtures are, you know. And there's a little thing over there with paper rolled up on it. Hang it right there. Each day, you open it to another rule, you see. And in 1 year's time, you'll have been through this book how many times? Several times. And you will be a good judge. That's what you'll be.
There's even a class called Order in the Court 101.
Your first rule when you have to get control, the first thing you say is, counsel, you talk to me and nobody else. If they want to say anything more, they come up and speak to you at the bench.
The lesson is never let two lawyers go at each other.
Otherwise, it's, I object, it's wrong, he knows it's wrong, he knew it was wrong when he got in his big Cadillac in Miami this morning with his big cigar, he knows it's wrong, and away it goes. Don't let him do that. Just crank the rules down, and you'll be in control.
Using the transcript of an actual trial, they play out a courtroom scene where things are out of control.
I'm entitled to use a verdict of not guilty to impeach this witness.
When you talk to me, do not come forward like you are coming, counselor. I am ordering you.
I don't care what you consider.
Judge number 5.
You are not to shout as you have been the very past instances, and I insist that you keep a reasonable distance from the court.
Pass the gavel. Judge O'Neill.
Your Honor, I'm representing Frank Dominguez, and I'm going to see that he gets a fair trial to the best of my ability. He hasn't received a fair trial all day because of you.
The disruption of this courtroom has been caused by you and my son's lawyer. My son is innocent. He is not getting a fair trial. My son is right, sir. You should step down.
Judge number 3.
I think you're absolutely right. We'll transfer this case to another judge.
Reading from the actual transcript of another trial.
Okay, Judge Hasslinger, you're going to give me an illegal trial. I'm going to blow your head off. Do you understand that? That is exactly what I'm going to do, punk.
What do you do when you are threatened in your courtroom?
Well, I would have interrupted him, and I would have told him...
Your Honor, I won't even dignify these stinking proceedings, punk. Go to hell. You're a dead woman, stone dead, Your Honor.
Well, again, I would have interrupted him just to say, bailiff, take that person away.
That's using the power of contempt in the courtroom. But what about threats outside the courtroom?
So I'm considering adopting my own private security system called a 25mm Beretta.
On your person?
Yes. I don't carry it now, but I'm getting a permit, and I intend to learn how to use it.
You don't carry a piece, do you?
I don't. My predecessor did at all times. Now I have some chemicals, some legal chemicals.
Mace?
No, tear gas.
All right. I think we all agree that the greater danger is in a civil rather than a criminal case. The people who you send to jail, amazingly enough, don't seem to hold it against you as much, but in these domestic cases...
It's personal.
God almighty. One of the things that I find just awful is to bump into somebody whose case you've just been ruling on, like in a domestic case, and you go into lunch and you get in, that is, that's the elevator, and there are 3 people on the elevator. You and the man whose child you just took away from him, and his mother. And they just kind of look at you like, you know, if looks could kill, I would be dead.
The first day on the bench can be frightening.
I wouldn't call it sheer terror, but I think there is some anxiety. A quick example is a judge who told me about his first day on the bench, and he put on his robe, walked into the courtroom, heard the bailiff announce him, all rise, court in such and such a county now in session. And so he said, I pretended to be shuffling through some papers, called the bailiff over in a very quiet voice. He said, Jim, what do you think would be the best way to proceed? And he said, Your Honor, why don't you say, call the first case? And I nodded with great gusto. I said, call the first case, and suddenly I was a judge.
All rise, please. The Honorable J. Burdett Pratt presiding.
Please be seated. Oh, by the way, after all this work, his appointment as a judge ends in November, and then Judge Pratt has to run for election.
I'm Judge Wapner from the People's